Hi, I'm Gary, and welcome to Estate Planning for the Real World, or How to Do Effective Estate Planning. Get your estate in order, know you and your loved ones are protected, and know you've taken care of everything you can. You will discover why planning matters in the real world, how an effective plan prevents probate and ensures your wishes, and what's in an effective estate plan. And I'll wager that nobody is using all these strategies exactly as they should, but everyone could. This is for you if you're frustrated with the thought of putting your family through probate, worried about the future and security of you, your spouse, your family, or your money, concerned about who will help you when you need help the most. Imagine you could wave a magic wand to prevent probate, avoid unnecessary taxes, protect your family and assets now and later, and stop worrying so you get peace of mind, all at a reasonable price. How would that make you feel? How much peace of mind and confidence would you get? That's what I'm going to show you how to do today. Why should you listen to me? Let me ask, if you don't do anything in 6 months, will you still be worrying about this? Will you be frustrated because you haven't got around to it? Will you be disappointed because you're not protecting you, your family, and your money like you should? Stop worrying. Gary helped us to get our affairs in order before our trip to Israel. It gave us peace of mind knowing everything was taken care of for our family. Gary is so easy to work with. We could not have been more pleased with him and his lovely wife, Winnie. We highly recommend DeWitt Law Firm for all your estate planning needs. When I was 40 years old, my dad passed away unexpectedly. Mom and I had to struggle through the rigors of probate. Neither of us had ever done this and were lost, confused, and worried for the entire time it took. Dad had a little money in a lot of places, and we had to find all of it. We had to find all the property, catalog it, inventory it, and then distribute it. All of this had to be done under the oversight of a judge and the attorney. And the attorney was billing us for every minute of time. Then later that same year, I was hospitalized with chest pain. It wasn't a heart attack, but it made me take a good long look at life. And while I was laying there in the hospital bed, I was worried about the future of my family. I was worried about both their financial security and their personal future. I was worried about who would make my decisions if I should take a turn for the worse. So laying there in the hospital, I knew there had to be a better way to do things. So I made up my mind then and there to go to law school, become a lawyer, and help people avoid probate and worry less about their future, their family, and their money. And that's just what I did. I went to law school at 40 years old, learned as much about estate planning and elder law as I could, and opened my practice to help you get peace of mind. And I completed an advanced law degree in estate planning and elder law to better help people. After finishing, I knew how to help avoid probate, control destiny, and get peace of mind. I wanted to help people, but they were afraid if they called I would send a bill, so I decided to practice in a different way. I decided to find a new way of working with clients to plan for their future, so when they needed me, they wouldn't have to worry about getting a bill. Now clients can call whenever they need to. I work with people like you every day to protect them, their family, and their assets so they can get peace of mind knowing they have taken care of everything they can take care of. And they don't have to worry about calling later with questions because I'm not going to start the clock to create a bill. Michael says I love this place. Top shelf legal help for wills, estates, trust, etc. They're hardworking, approachable, caring people with their clients' best interest in mind. Why am I teaching this? Because I had to take my father's estate through probate. And nobody needs to put their family through probate and more. And I just love helping others. What you're going to learn today: why planning matters in the real world, why to prevent probate and how to protect your rights. Why does planning matter in the real world? If you own anything, you have an estate. Your estate is your property. Your property is your estate. You need to know that the government has written an estate plan for you, but you don't have to use it. I think that's worth repeating. The government has already written an estate plan for you if you don't replace it with your own plan. It's in Title 28 of the Arkansas Code and literally consists of thousands of pages of laws and court rulings. Their plan makes it difficult to protect your family and for your family to protect you. You have an estate. Your property, that is your house, cars, 401k, life insurance, jewelry, clothes, and more, is your estate. Your property is your estate, and planning protects property. If you don't write it or haven't written your own plan, then the government, legislature, and courts have a complex plan written for your estate. This is your default plan. Leave it up to the legislature and courts to make a convoluted system to pass your property to the next generation. Most people call it probate. Technically, if you don't have a will, it's called intestate succession, but I'll just call it probate. If you only have a will, you must still go through probate. Wills alone don't prevent probate. And even if you own everything with somebody else, sooner or later there's only one owner. And putting your children on a deed and accounts has its own dangers. Without a will, the law tells the judge who gets how much and when. However, it doesn't tell the judge what each person is to get. With a will, you tell the court who gets what and how much. You need to know probate will take a minimum of 8 months. There's a built-in 6-month waiting period for creditors to make claims. Add some administrative time to the beginning and end, and 8 months is about the minimum. Probate costs 3 to 6% of the gross estate at the minimum. If anybody contests the process, then it could cost much more. You have fundamental rights. Those basic rights are the right to privacy, the right to make your own decisions, and the right to make healthcare decisions, including the right to refuse treatment. A plan helps ensure your wishes are carried out the way you want and protects your rights. If you can't make rational, informed decisions, then without a plan, your family will have to go to court to get permission to manage your affairs. Or Adult Protective Services could step in and take over your life. A judge takes your rights away and gives them to somebody else. Your private affairs can end up in the public record. Your right to make decisions is given to somebody else. You can write your own plan and protect your right to privacy and your right to manage your own affairs. If you don't have a will or just a will alone, your family could face probate and more. James didn't think he would ever need an estate plan, but in his 60s, he developed rapid onset dementia. Because he didn't have a plan in place, his son had to go to court to get a guardianship and manage James' money, property, and health care. Then, when it came time to sell James' house, he had to spend more money, go back to court to get permission to sell the house. And if James' daughter had fought the guardianship, it would have been even worse and more expensive. Because James didn't have a plan, James' son and daughter had to go through probate to divide up his estate. They quarreled at every step, adding time and expense to an already lengthy, expensive process. Now, James' twin brother Joe created a comprehensive estate plan with everything he needed when he was in his 50s. Like his brother, Joe developed rapid onset dementia in his 60s. Unlike James, Joe's children could use his plan to manage his affairs and then settle his estate quickly without fights. He used his own plan, not the government plan. And finally, Bill thought that just a will would prevent probate. But remember, having just a will doesn't prevent probate, as his family discovered when they tried to sell his house. Instead of being a smooth, quick transition, Bill's family had to go through the expense and hassle of probate to get the house sold and the estate settled. How do you get started on your plan? The first step is to take a general inventory of your estate. You add up rough estimates of what you own and what you owe. Be sure to include bank accounts, investments, real estate, and personal property. Write down where your accounts are located. A step-by-step fill-in-the-blank organizer will help. If you stick around for a bit, I'll tell you how you can get yours. Decide between a will or a trust at the center of your plan. We'll go over how to decide which one should be at the center in a few minutes. And finally, you'll pick the people who will fill the various roles in your powers of attorney. I've known Gary for many years, and the one thing that stands out about him is his ability to take an issue and work to find the best possible solution to the problem. He is not afraid to dig in and work many hours to learn something new to help with the task or just to better his own knowledge. What is probate? How do you avoid probate? And should you use a will or a trust? Leave it to our court system and legislatures to create a cumbersome, slow, expensive process to pass your property from you to your loved ones. Without a plan, the legislature has decided, and the court enforces how much each family member gets, when they get it, and how they get it. Just for this presentation, I downloaded the laws covering the administration of an estate. After waiting quite a while for it to download, I opened it. Just the laws were 365 pages, and that doesn't include all the court rulings on those laws. You prevent probate with a will, an additional planning, or a trust. A will requires probate to be validated and activated. A will plus some additional planning will prevent probate for your major property, leaving only the little stuff. Arkansas has a way to pass small probate estates without the need to go to court in most cases. A will is really nothing more than just a list of instructions on how to pass your property to the next generation and nominating somebody to care for minor children. Also name somebody to oversee taking the document through court, the executor, to manage the property until its final distribution. You can be very detailed in the instructions, or you can be very terse. I've seen wills from 4 pages to 40 pages, depending on how detailed they were. Wills require probate to be validated and for the property to be passed out. That's right, wills require probate. Wills are just the instructions to the probate court. Keep this in mind. A will can create a trust. It's called a testamentary trust, and they have their place in planning. Also, a will does nothing during your lifetime to protect you, your money, your family, or your rights. In order to avoid probate with a will, you need additional planning. The goal is to get as much of your estate passed outside of probate as possible and use the will as a catch-all. Your will should just cover the little stuff if there's anything at all left outside of probate. Your major property should be set up to pass outside of probate. With a trust, the person creating the trust is called the trustor or grantor. Grantor simply means they gave property to the trust. The person who legally owns the property in trust and manages it is called the trustee. The person who gets the benefit of the property is the beneficiary. A trust is a contract between two people, the trustor and the trustee, for the benefit of the third person, the beneficiary. A living trust is created during your lifetime. A testamentary trust is created in a will. The most common type of trust used in estate planning is the revocable living trust. Revocable means that it can be changed during your lifetime. Living means you set it up now. With the trust, you are usually the trustor, trustee, and beneficiary during your lifetime. However, if you should become incapable of managing the trust, you can name somebody else to step in and manage the property, your successor trustee. When you pass, the trust usually becomes irrevocable and its instructions are carried out by the trustee you named without probate. Some of the advantages of a trust is the trust property is managed during your lifetime and probate is avoided for all the property in the trust. If we look at Bill's story again, his family was surprised that a will required probate. Bill thought that just a will would prevent probate. But just a will doesn't prevent probate, as Bill's family discovered when they tried to sell his house. Instead of being a smooth, quick transition, Bill's family had to go through the expense and hassles of probate to get the house sold and estate settled. If Bill had done some additional planning, then his family could have avoided probate to sell the house. Of course, if Bill had used a trust, probate would be avoided too, for everything in the trust. The moral of this story is that you can prevent probate with proper planning. There are times when a will and some additional planning is enough, and there are times you need a trust. The hard part is figuring out which is the best for you. Choosing between the two is often not straightforward and takes the guidance of an expert in estate planning. You need to take inventory of your family. Here are a few of the questions you need to ask yourself. Does anybody in my family have special needs? Are any of your children under 18? Are you leaving it to grandchildren? Are any of your children addicted to drugs, alcohol, or gambling? These are just a few of the questions that you need to ask yourself. At your estate planning action meeting, I go through an entire set of questions that helps us decide if you need a will and additional planning or a trust for you and your family. Gary DeWitt is an incredible attorney. He and his wife Winnie are sincere, down-to-earth people who just want to help keep your estate out of probate. There is more to estate planning than just deciding who gets your stuff. You also get to decide who will be able to legally help you when you need help. Powers of attorney help you and your family avoid court. Powers of attorney help you protect and preserve assets and dignity while living. They also make sure that somebody you know and trust is there to help you. Many people confuse a trust and a durable power of attorney. There are certain things you can't do with a trust. You can't give people the power to sue on your behalf or manage assets not in a trust. Trust can't outline your medical decisions or give people permission to talk to doctors and nurses. A trust can't manage insurance policies it doesn't own. If you have a trust, you still need a durable power of attorney to manage those things. If you don't have powers of attorney for financial, legal, and healthcare decisions, then your family could end up in court to get permission to make your legal, financial, and healthcare decisions if you can't make rational, informed choices. That is called a guardianship. There are 4 documents you should have. First is the durable power of attorney. This covers financial and legal decisions. You need a healthcare power of attorney. This document covers your health choices. Third is a protected health information release, also known as a HIPAA waiver. Without this, your family can't get updates on your medical conditions from the doctors or nurses. And finally, a living will or advance directive. This tells the doctors what treatment you want if you're in a vegetative state or can't otherwise make medical decisions and the end is very near. Another consideration is protecting your assets from the cost of long-term care. So many people fall into a gray area. They have too much money to qualify for Medicaid and too little to pay for the cost of long-term care. Proper planning, as early as possible, can help protect assets from being spent on long-term care. The full scope of long-term care and Medicaid planning would take hours, but basically it comes down to this. Buy long-term care insurance if you can. Plan as early as possible. Medicaid has a 5-year look-back, and giving assets to a trust is considered a gift and will count against your eligibility. If you find yourself in a position you need immediate care, then consult with a qualified elder law attorney for emergency planning to maximize the amount your family gets to keep. James didn't think he would ever need a plan, but in his 60s he developed that rapid onset dementia. Because he didn't have a plan in place, his son had to go to court and get a guardianship to manage James' money, property, and health care. And when it came time to sell James' house, he had to spend more money, go back to court, and get permission to sell the house. Barbara's mother had started buying everything and anything from anybody that was selling. She had lost her ability to say no to any salesman. Fortunately, Barbara had a power of attorney in place that allowed her to take control of the accounts and contracts and stop her mother from buying from every telemarketer and door-to-door salesman. Later, when Mom moved to assisted living, Barbara could handle selling the house and taking care of everything else without going to court to get permission. Your next step is to pick who will stand in your place if you can no longer make sound, rational, informed decisions. You also need to look at your age and health to decide how and if you want to try to shield assets from Medicaid. We have used DeWitt Law Firm since coming to Springdale. They walked us through every step of estate planning and what to do when. Gary and Winnie have huge hearts and the knowledge you need to protect your assets. So far you've discovered why planning matters, how to prevent probate, and disability planning and asset protection. Get this one thing. You're going to have your financial house in order and know that you and your loved ones are going to be protected, and that you personally are going to feel good. Your stress will be relieved because you know that you've taken care of your family and everything you can take care of. You're going to get peace of mind and confidence that your family is protected. How do I make this happen? First, you can do it by trial and error. You can research on the internet and try to do it yourself. Or you can use my proven system. The Estate Planning Action Meeting. This is what you will get when you come in for your initial, free, no-obligation probate prevention and asset protection blueprint meeting. First, you're going to get an hour of my time. Unlike a typical 15-minute phone consultation, you won't be rushed to try to get your questions answered and then pressured to sign up. Everything we talk about during this hour is completely confidential. What is said in my office stays in my office. You get 60 minutes of my time to go over your goals and wishes. answer questions, and outline the plan that is best for you and your family. It takes about an hour for us to get to know each other, go over your goals, understand your family, and outline your plan. And during this time, I'll do my best to educate you on your options and what they mean. However, if you have any lingering questions after our meeting, feel free to pick up the phone and call me. Once we're done, you have the choice to shake hands and leave without obligation or continue and create your personalized plan. Normally, it's $2.25 an hour for my time, and some lawyers would charge you for the initial meeting. I've been there and done that. Not only do I have a family to protect, I have the family farm that I've had to plan for. And in addition to a law degree, I received an advanced degree in estate planning and elder law. Many hours have been spent streamlining and simplifying the planning process so that you don't have to spend an excessive amount of time on your side. Also, experience has shaped and guided my document creation. I stand behind what I do. I know my stuff stands up in court because I followed it through in many cases. And speaking of court, I also do probate work, so I know what you need to do for your family to avoid probate and simplify things for your family and loved ones. The cost of attending classes and gaining that experience is quite high. When you come in, if you don't already have it, I'm going to make sure you get a copy of Secrets of Excellent Estate Planning. I wrote the book to educate you in an easy-to-understand way in the comfort of your own home. And there's more. You're going to get the Estate Organizer. Once you complete this organizer, you will have your financial house in order. All you need to do is fill it in. 90% of the hard work has been done for you. You will have the information your family will need in one easy-to-find location. A lot of time and effort has gone into making this organizer easy to fill out. But there's even more. Also known as a living will, this document describes what treatments you want or don't want in your last hours if you can't make those decisions. I'll make sure you go home knowing how to fill it out and what's required to make it legally binding. Let's go over everything you will receive when you have your estate planning action meeting. You're going to get an hour of my time, my professional experience, the book, an estate organizer, and a living will. What would it be worth to you to have your financial house in order and know that you and your loved ones are going to be protected? And that you personally are going to feel good. Your stress will be relieved because you'll know that you've taken care of your family and everything you can take care of. What is peace of mind really worth? The total value of this consultation with everything you get is $882. But if you're one of the first 10 people to make an appointment this month, you'll get it not for $882. I've opened up 10 slots where you get your estate planning action meeting free of charge and without obligation. And I personally guarantee if your appointment is more than 15 minutes late, I'll give you $50. Call 479-717-6300 now to book your appointment. Phones are answered 24 hours a day, 7 days a week. Or visit planwithgary.com. Remember, you're going to get a relaxed environment, 1 hour of my time, my professional expertise. I'm going to answer your questions. You'll get the planner, an advance directive, and my personal guarantee today, free or for 3 payments of only $0. Call 479-717-6300 now to book your appointment. Phones are answered 24 hours a day, 7 days a week. Or visit planwithgary.com. Remember, you're going to have your financial house in order and know that you and your loved ones are going to be protected and that you personally are going to feel good. Your stress will be relieved because you know that you've taken care of your family and everything you can take care of. You are going to get peace of mind and confidence that your family is protected. Call 479-717-6300 now to book your appointment. Phones are answered 24 hours a day, 7 days a week. Or visit planwithgary.com.